Jackson.
Ashley Feltus for the people.
He's on hold. Apologies, Your Honor.
No, it's okay. I saw your name and I'm like, okay, whatever.
J. Grant Miller, P58658 on behalf of Mr. Jackson. It was a late appointment. I haven't even spoken to him at Macomb County yet.
Yes, he's there. Can you state your name?
Kenyon Jackson.
Thank you. All right. So it was a late appointment and you're looking for an adjournment.
Yes, Your Honor. I'd like to get the discovery and discuss it with Mr. Jackson.
All right. Mr. Jackson, I'm going to adjourn your probable cause conference in your two cases. I'm going to adjourn them to January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
And we'll continue. Thank you. First case of the People versus Rohamio Smith.
Ashley Feltus for the people.
Assistant Public Defender Natalie Kate with and on behalf of Mr. Smith, who is via Zoom at the Forensic Center. Sir, can you please state your name for the court?
I'd like to say I'm sorry about all the confusion I'll cause or all the misheld belongings or
State your name.
or I don't know why to say. I'm just trying to say I'm sorry about any items I saw and mishap. I'm sorry, I wasn't in my right mind. And I'm doing better with the help of the judge.
That's Judge Simpson doing what he does best, cutting through the noise. The defendant attempts an apology but never quite reaches it. And Simpson doesn't linger on emotion. He isn't rude, he's efficient. He moves past sentiment and goes straight to the forensic report, because this isn't about feelings. It's a legal determination of competency, and he delivers it with speed, clarity, and control. Just another day in the steady rhythm of the courtroom.
Thank you. That's close enough.
Mr. Smith,
Go ahead.
Your Honor, is Your Honor in receipt of the 90-day progress report from the Forensic Center dated November 25th of this year?
I am.
Thank you.
The
Sorry.
report indicates that the defendant remains incompetent to stand trial at this time.
Yes,
Is there any other additional evidence?
nothing from the defense, Your Honor.
Anything else from the people?
I'm so sorry, Your Honor. I have nothing other than the report that's been submitted, the progress report.
All right. And I don't think our time period has passed.
No, Your Honor.
They do apply a substantial likelihood that he will attain competency.
They do. So I'll need an order, but I'll set a competency review hearing. Whatever. Because February 26, 2026.
Thank you, Your Honor.
Sir, very nice meeting in trial. Sir, too much space in between these court dates. I'm losing a lot of things, in between. I'm losing a lot of things. Family and everything. So you can just make this,
I understand,
All right,
Mr.
thanks.
Smith. We'll be in touch, okay? Oh, sorry.
All right, bye.
Thank you, Your
Thank you.
Honor.
Bond will continue. Court does call the case. People versus James Cobb. Or Cobb. Yeah, Cobb.
Good morning, Your Honor. Kerma Dadush of Mr. Cobbs is approaching. Good to be back.
Good morning, sir. What's your name?
James Cobbs.
Okay.
Your Honor, we don't have discovery on this case yet. We'd be asking to adjourn. I believe this is the first PCC on this.
It is. That objection, probable cause, will be. Can't hear over, Dave. What'd you say? I can't hear over. Okay. Who are you? Oh, never mind. January 8th, 2026. Where's Anna Blevins? 9 a.m. Bound continue.
Thank you.
Are you just doing this, Anna? No? Okay. We'll work it out. Court calls the case. People versus Perry Malone.
Ashley Feltus for the people.
Good morning, Christina Saxon for Perry Malone.
Good morning.
Morning, yeah.
Mr. Malone, can you state your name, please?
Harry Malone.
Thank you. What are we doing on this?
Your Honor, I'm asking for an adjournment. Ms. Feltis said they're still trying to get the discovery that I requested.
Okay, so we're trying to work on discovery issues.
We are, Your Honor. Thank you.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank
Thank
you.
you. Court calls case of the people versus Joseph Bonville.
Good morning, Your Honor. Christina Saxon for Joseph Pondville, who's approaching.
Your name, sir?
Joseph Bonville.
Thank you. Okay, what are we doing?
Your Honor, I'm asking for an adjournment as I'm awaiting discovery. I was just pointed to this on Thursday.
Adjourn this matter to January 8th, 2026, 9 a.m. Bond continued. All right, thank you.
Your Honor, may I make a?
I'm sorry?
I was asking for to make a bond argument, but see.
Oh, okay, he needs to come back up then. Go ahead, briefly.
Your Honor, Mr. Pondville is in jail on retail fraud. From the written discovery that I have, there seems to be some confusion as to whether it was him or not, and I'm asking for a nominal bond, being that it was a non-assaultive offense.
People would object. The confusion around whether it's him or not was because he's alleged to have been using his brother's name while he was committing this string of retail frauds. There is an additional retail fraud charge that I am reviewing right now. In fact, I was just given the video for that moments ago that I'll be reviewing. It looks like him and another brother of his continually go in and out of different stores in the area and steal whatever they want. Mr. Bonville has an incredibly long criminal history with dozens of retail frauds dating back decades, in addition to long stints in prison for other theft crimes. He's held on a multitude, at least he was held on a multitude of cases. I don't have ex-jail up, so I can't make that representation accurately at this moment, but the people would object.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case. People versus Dion Baldwin.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Where are they? Oh, he's coming out.
And good morning, Your Honor. Assistant Public Defender Ben Dunaway on behalf of Mr. Baldwin, who stands to my right.
Your name, sir?
Mr. Dion Baldwin.
All right. You're seeking a forensic evaluation? Or
Yes, Your Honor.
If I may.
Well, hold on a second. Actually, did you get a report?
No, I submitted the referral form to the clerk of the court by email yesterday. He's not yet been.
Order for an evaluation. Right, I see that. Okay, I'm sorry. Got it. All right.
If I may speak, Judge.
You wanted to say something? What do you want to say?
Yeah, so I wanted to relieve my public defender yesterday when he came to visit me. He just was incoherent with what I was saying. I wanted to proceed with a preliminary examination with 3 people to show for their side: Nicole Jones, Robert Jones, and Booker T. Jones.
What do you mean he was incoherent? You couldn't understand him?
Yeah, he didn't seem to be understanding what I was saying. He was asking me if I was the owner of the home. I was telling him no. I was applying for personal rep of the property.
So he was asking you whether or not you had ownership in the home on a home invasion case.
Yes.
What a shock.
My brother was the last to have ownership,
So
and that was.
It's not really in your interest to discuss any facts of the case with the judge, whether you like me or not. It's not good for you to tell him the facts. It's best for you to be quiet, Mr. Baldwin.
So the 11/6 was the date.
So, sir,
of the last rep. Now
that involves a probate proceeding, right?
Yeah, so I have 63.
That's why your attorney was doing the proper thing, just based upon what you're saying, and asking regarding certain things regarding that. I don't need to know the terms of that, but that's just a natural kind of thing. And sometimes if people don't really know what the probate issue is, it's hard to explain, which may have, and you probably were doing it improperly and not with the proper terms, which is probably why counsel may not have understood it.
Watch this legal jujitsu unfold. The defendant tries to fire his lawyer for being incoherent, but in doing so accidentally proves the attorney was doing the job exactly right. Simpson spots it instantly. Those weren't random questions. They were directly tied to property ownership in a home invasion case. The judge shuts the argument down and delivers an impromptu lesson on why it fails, showcasing patience, experience, and sharp legal intellect all at once.
May not have understood exactly what you were saying. It has nothing to do with him. So your motion to try to relieve the public defender's office, if that's your reason, is denied.
No problem.
And I will order the competency evaluation, and I'll set that for March 26, 2026, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls the case. People versus Lucretia Pender.
Help us with the people.
Got it. Hang on a second, Miss Pender. Zaid. He's in Zoom. Your attorney, there we go. All right. Call the case, counsel. It's going to be one of those days. Mr. Zaid, I called the case. I don't think he can hear me. He just dropped. Miss Pender, I'll recall your case. He just dropped off our screen.
Okay.
Okay. Thank you, ma'am. Court does call the case of the people versus Mary Barney.
Alexander, on behalf of the people.
The public defender Natalie Pate with and on behalf of Ms. Barney, who stands to my right.
Mary Barney.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am requesting an adjournment of both files. I do have a correction to what I wrote in the green sheet, which was correct at the time. Our office has now received discovery in the second case late yesterday afternoon. That being said, we are still requesting an adjournment in order to review it and discuss it with Ms. Barney. Then I do have a very brief request as to bond when appropriate.
Probable cause conference, January 8, 2026, 9 a.m. As to bond.
Thank you, Your Honor. I did speak to Ms. Zenda regarding this, and I do understand that this request was made at the last court hearing regarding this case. We are requesting that Ms. Barney be released to inpatient substance treatment. The only thing that has changed since this request has been made at the last hearing is that Ms. Barney has now been arraigned on the companion case, and it is my understanding that she is now arraigned and there are no new cases coming, so to speak. Outside of that, Your Honor, I'm just asking if Ms. Barney could be allowed to be released to inpatient treatment.
Response.
Your Honor, I'm going to object again. The reason I say agree, I just don't think that's inappropriate. At this time, for Ms. Barney, I have concerns about the community. I have concerns about the victims. We've talked with them. They are on board. They're extremely afraid of Ms. Barney and the escalation in her behavior with violence towards them and their child that was in the home. So I'm just going to object for the reasons I previously stated at this time.
And the court's going to continue its order. I'm going to deny the request. Her bond will continue. Thank you.
Understood, Your Honor. Thank you.
Court calls the case People versus Michaela Whitfield.
Ashley Feltus for the people.
Good morning, Your Honor. May I please support Todd Kaluzny on behalf of Ms. Whitfield?
Ms. Whitfield, can you state your name, please?
Michaela Whitfield, Your Honor.
Thank you. All right, what are we doing?
Your Honor, we had a probable cause conference on December 11th. We adjourned to today's date for discovery. There's some outstanding videos that I still don't have. I talked to Miss Feltus yesterday, and she is still looking into getting those videos for me. So we're asking for another probable cause conference.
That's correct. I have reached out to the Michigan State Police. We're looking for a video from an interview room at the post, in addition to one other trooper's video. We have several videos. We're just looking for a couple more.
Got it. Okay. You think you can get that to them? And if I set this for the 15th,
I hope so, Your Honor.
All right. Probable cause conference will be adjourned January 15th, 2026, 9 a.m.
Thank you, Your Honor.
All right, Bond, we'll continue. Thank you.
Thank you.
Thank you, Ms. Whitfield.
Thank you.
Court calls the case. People versus Kurt Bushland.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Bushline, who approaches the podium.
Kurt James Bushline.
Okay. You're seeking another adjournment.
Your Honor, we're trying to contact Gratiot County, and I'm just having a little more difficulty than I thought I would. So if we could possibly put it over to the 15th, we're trying to get a universal kind of settlement.
You want the 15th?
Please.
All right. Without objection, probable cause conference January 15th, 2026, 9 a.m. Bond.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case. People versus Dylan Marshall.
Good morning, Your Honor. John Dakmack appearing on behalf of Mr. Dylan Marshall. We consent to these virtual proceedings. Mr. Marshall is in the state of New York at this time.
All right. Mr. Marshall, can you state your name, please?
Yes, Your Honor. Dylan Marshall.
Thank you, sir. All right. What are we doing?
Your Honor, the government has offered us a plea resolution. We've accepted that. Your Honor should have written copies of those. We're ready to proceed with the plea hearing.
Plea agreement in front of me without a blue tag. Just saying. That indicates that the defendant will be pleading guilty to an added count 2 of larceny, 200 to 1,000. That the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement of under 771.1 treatment, whereupon if successful, term of not more than 12 months of compliance, the case would be dismissed. I see. All right. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that correct, Counsel?
Yes, Your Honor.
Mr. Marshall, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Again, state your name for the record, sir.
Dylan Marshall.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that becomes the maximum fine. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Balvo or her successor in the 15th District Court. Do you understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
I do.
You signed an advice of rights form or had one caused it to be signed on your behalf? Is that correct, sir?
I believe so, yes.
All right. You recall signing a form of advice of rights?
I do.
All right. Do you have any question regarding any of those rights?
I do not.
And you understand that by pleading guilty, you'll be waiving or giving up those rights?
I do.
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
For this, yes. For anything else, no.
Mr. Marshall, you're not on probation yet. Are you on probation or parole right now for any other offense?
I am not.
Sorry, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
On September 9, 2024, at the location of 1200 South State Street, City of Ann Arbor, Washington County, State of Michigan, what did you do that makes you think that you're guilty?
I stole a Michigan football helmet and a national championship baseball hat.
All right. And that was from Schembechler Hall?
It was.
All right. And you had no property interest. Those items that you took didn't belong to you. Is that correct?
That is correct.
And you didn't have anybody's permission to take that property, did you?
I did not.
Do you believe that the value of the property that you took was in excess of $200?
Yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would, first of all, not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
January 20th at 9 a.m. before Judge Bravo.
January 20th, 2026, 9 a.m. Scheduled before Judge Balvo or her successor. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Christopher Brewer.
Overwater Assistant Prosecuting Attorney for the People.
Assistant Public Defender Ben Denowitz for Mr. Brewer, who is joining me at the podium now. Would you state your name for the record, Mr. Brewer?
Christopher Brewer. Thank you.
And, Your Honor, we would like to set this matter for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses with 6. People have their witnesses available January 6th.
I believe so, Your Honor.
Preliminary examination in person, January 6, 2026.
Don't leave.
9 a.m. before Judge Barr. Bound will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Jessica Williams.
That's Overwater Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Justin Zaid appearing on behalf of Ms. Williams. President consents to appear via Zoom. Ms. Williams, can you state your name?
Jessica Williams.
Thank you. All right, what are we doing?
Your Honor, this is the date and time set for an adjourned PCC. Last time we were here, early December, we submitted a deviation request. We still haven't received a response to that, so we're just awaiting word from the prosecutor's office.
Is that correct? The prosecutor's office is in receipt of it? What are we doing?
Checking right now, Your Honor. I do not see that in our file, so I wasn't aware of that. I will get with Mr. Zaid and make sure that he gets put in there.
For the record, it was originally sent to Mr. Cook. He indicated that he would be off the file and would forward it on to the assigned prosecutor.
All righty then. Here's what I'll do. You guys get that straightened out. I'll adjourn this to January 15, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Understood. Thank you.
No, that one. Where's Mr. What'd you do with Mr. United? I'll just call him. Court recalls the case People versus Lucretia Pender.
Justin Zaid on behalf of Ms. Pender. Ms. Pender, can you state your name?
Lucretia Pender.
Thank you. What are we doing?
Your Honor, in this case, the court will see it is a welfare case, so there is some additional contact I need to have with the office that investigates these cases to see about what sorts of things they'd like to see as a result. You know, courts familiar, sometimes they want to see a
Right.
forfeit benefits, things like that. So I need a little bit more time to work on that.
That objection, I'll adjourn the probable cause to January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Will continue. Thank you. Court calls the case, People versus Devon Brown.
Assistant Prosecuting Attorney for the People.
Greg Pappen appearing on behalf of the Attorney General.
And good morning, Your Honor. Assistant Public Defender Alexis Served with and on behalf of Mr. Brown, who's approaching the podium.
Are both of these Attorney General is?
No, Your Honor.
No, one is a state case. So. All right. Your name, sir?
Devon Brown.
Okay. So in the Attorney General matter, he's waiving.
Your Honor.
Correct. All right, sir, you're waiving your right to a preliminary examination in the case involving your failure to pay child support?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Acknowledge receipt of the information, waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, or will enter a not guilty plea to all counts. Pretrial will be set for
January 7th at 1:30 before Judge Conlon.
January 7th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue in that matter.
Your Honor, may I just bond briefly in that matter?
In which one?
The child support case, Your Honor.
You want to address bond?
Yes, Your Honor.
Go
Mr.
ahead,
Brown.
take a shot.
Mr. Brown would like me to ask the court either a reduction or a personal bond, Your Honor. When this matter took place, he had just recently lost his job. In Houston, he came back to Michigan to support his little brother who's special needs. He helped take care of his brother. He has been fighting for his daughter for the last 10 months. Before being brought into custody, he was working 4 different jobs. He was shipping cars, doing DoorDash, working down at Eastern Market when there was home line games, and working as a sous chef at Blue Cross Blue Shield, Your Honor. He's been in custody for 8 days as of today.
But the bond was set at 25% of what the outstanding charge was, correct?
Correct, Your Honor.
Well, I don't think statutorily I can necessarily do anything with that, and I'm not inclined to. But you can go ahead and finish your argument if you want.
Your Honor, that was the last point that I was going to make, is that he just wishes to get back to work so he can start paying on those arrearages and move this case along.
I understand that. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Understood, Your Honor.
Thank you.
And then on the other matter, his state case,
Yes.
we were just requesting an adjournment on that one, Your Honor. We got discovery late yesterday, and we need a chance to review that with him.
Is there a green sheet on that one?
I
Oh, you
believe I
might have given
resubmitted
it to
Your
me.
Honor.
I think you did. It's just other file. All right. That objection, probable cause, January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Case, People versus Harold Couch.
And good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record, please.
Harold C. Couch Jr.
Your Honor, we're here again. We are awaiting the DNA test results in this. I've spoken with Mr. Kennedy, not recently. I believe he's out of state. That's why his case is being covered. So I don't have an immediate update on the whereabouts of these results. I've been requesting them for some time. And I have no doubt that the Forensic Center, that the Forensic Science Division will get there. I can't say when.
And I don't have an update on the time frame. Last update I got from Mr. Kennedy was that we just don't have the report back yet. I didn't give a time frame.
During this matter, January 22nd, 2026, 9 a.m.
And thank you so much, Your Honor. Your Honor, I do have an 8:30 in 34th District that day.
Sorry.
You're more important.
I'm sorry to hear that. So what do you want me to do? Call them and tell them cancel their docket?
Absolutely.
Or are you asking me to do something that I'm not going to do?
That's what I'm doing.
Okay.
This is absolute gold. An attorney asks whether Judge Simpson can call another court and cancel their docket, and his deadpan response, "That's what I'm doing," lands perfectly. The follow-up is legendary. A clean, surgical shutdown that's equal parts funny and firm, and a clear reminder who runs a room. It's in these unscripted moments that a judge's personality truly shines.
That's what I'm doing.
Okay.
I'm doing the second one. And if I could
Not
get...
doing it. Stop, right? You're not doing it.
That's what it is. It's a,
like Hall?
Attrition. I think I could do the conflict waiver in no less than 300 words, by the way. I know 20 or 30 was talked about.
Yeah, that would take
piece
forever.
that long, Judge.
The fact that you said that, I realize I'm very blessed by the people doing it. So what do you want me to do?
So if I could just come in a bit later that day. I mean, I'm sure I could be here by 10:30.
We'll wait with bells.
Thank you so much, Your Honor. I appreciate you.
Court does call the case. People versus Sadera Akiji. 3 cases.
You want to do it down here? Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on the case ending in 1678.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Akiji on the other 2 cases, the ones ending in 5790 and 5801. Mr. Akiji, can you state your name for the court, please?
I think he was saying it.
Thank you, sir.
What are we doing?
Your Honor, we're here. We've requested a competency evaluation and also criminal responsibility evaluation. I also sent over some supplemental materials there.
And I do have the same request for both of my files, Your Honor.
Okay, I have did you submit? They're in there. Okay, they're just not marked. Okay. So what I will do is I will sign that for the forensic evaluations. Set competency hearing in this matter for March 26, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Hi, Mr. Ikeji.
Court calls the case of the people versus William Riddle.
And is it on behalf of the people, Your Honor?
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium.
Your name, sir?
William Michael Riddle.
All right, what are we doing?
We had set this day to make sure that I had all the discovery. I've spoken with Ms. Zenda at great length. I have all the discovery, and I believe we have an exam set for next week, Your Honor. We're good to go.
And Your Honor, this was the case where we originally thought we had it discovered before. We were up last week and the court indicated they would set it on the 30th.
Right, I had not said it yet, but I would set it on the 30th. Okay.
My apologies, Your Honor. I thought it was already set. I had such faith in Ms. Zenda's office.
Preliminary examination in person will be set for December 30th, 2025, 12 noon, and that is before me.
Thank you, Your Honor.
Thank you. Calls case, People versus Amber Almany.
Assistant Prosecuting Attorney to the people.
And Assistant Public Defender Natalie Pate stepping in for Mr. Gaddy on behalf of Ms. Almy, who stands to my right. Please state your name.
Amber Almany, Your Honor.
Thank you.
Thank you, Your Honor. I do have a green sheet prepared by Mr. Gaddy, Your Honor. We are requesting an adjournment for mitigation purposes.
Without objection, probable cause conference will be adjourned to January 15th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court calls the case of the People versus Moses Cunningham Page.
Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Earps with and on behalf of Mr. Cunningham Page.
Your name, sir?
Moses Cunningham Page.
Thank you.
Your Honor, he is executing a exam waiver right now. And Your Honor, with that,
Sir. Go ahead.
I did submit an order for release to inpatient treatment that was going to be a part of the agreement between defense and the prosecution for an order that may be available to him in circuit court.
People have no objection to that order.
No.
But he does need, yeah, you're gonna need a tether proprietary place. All right. So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
All right. People also waive their right?
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We acknowledge receipt of the complaint, waive the formal reading, and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 6th at 1:30 before Judge Company.
January 6, 2026, 1:30 before Judge Company. Bond will continue.
Thank you, Your Honor.
All right, thank you. Court calls the case of the People versus Edward Casto.
Actually, called this for the people.
Awesome, bill based on behalf of Mr. Edward Castro. Castro, can you state your full name for the record?
Edward Casto. Thank you.
Yes, Your Honor, today is the date and time set for a probable cause conference.
I know.
We have a waiver here. My client is waiving and he's due to enter into the sobriety court circuit.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yep.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information. We waive formal readings and stand mute to the charges.
Defendant never waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for February 12, 2026, 1:30.
Your Honor, may I address bond when appropriate?
Before Judge Slay.
May I address,
what?
May I address bond when appropriate?
He's out.
Yeah, he's just on a tether.
You're gonna blow it. Go ahead.
Your Honor, my client is asking that he be able to turn in his silver link. He's been on it for 3 months. He's due to enter into the sobriety court. He's just looking to save some money and get rid of an expense that may not be needed at this time.
Well, when is he getting into the? Here's what I'm going to do. I don't need a response from people. I'm going to deny your request. I think certainly once he's in that program or at some point, given their evaluation, I think they'd be in a better position to rule for the removal of that. So I'm going to deny your request. Bond will continue with its condition.
Understood. Thank you.
February 6th, Your Honor.
What was that date, Your Honor? Yeah.
Seriously?
Yeah.
Mr. Castro, you know the date? What?
I think it was February 6th.
I thought 12.
No, it was February 12.
Yeah.
12.
That was really early.
All right. Everybody got that now?
Got it. You're on the
February 12.
February 12.
Thank you. Jeez, oh Pete. Said it like loud, like 8 times.
I didn't put it there, you did. Okay,
I'm busy.
Okay.
Court calls the case People versus Javante Jackson.
And send out behalf of people.
I don't know. That's the best I can do.
Thank you, Your Honor. Custom bill based on behalf of Mr. Javante Jackson. He's present to my right. Javante, can you state your full name for the record?
My name is Javante Jackson.
Thank you.
This time we're going to be requesting to set for preliminary exam.
All discovery is completed.
To our knowledge, yes.
People have their witnesses available to sit. Preliminary examination in person will be set January 6, 2026, 9 a.m. before Judge Perry. Bound will continue. All right, thank you. Court calls the case of the people versus Jasmine Morris.
National Feltus for the people.
My address on behalf of Ms. Morris. Ms. Morris, can you please state your name for the record? Can you please state your name for the record, Ms. Morris?
Jasmine Morris.
Yeah. Thank you. You're requesting a forensic competency.
Yes, please, Your Honor. It's submitted.
Forensic evaluation competency is ordered. I've signed those orders. I'll set the hearing for March 26, 2026, 9 a.m. Bond will continue. Thank you. Thank you, ma'am.
I have a question.
Of course you do. Yes. Yes. What is your question?
Is it any way we can like drop the charges because it happened a while back ago?
Ms. Morris, we can come talk to you after court to discuss that with you, okay?
Yeah.
Thank you.
Okay, thank you. Court calls case, People versus James Holmes.
Lieutenant Overwater, Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Holmes, who approaches the podium. Please state your name.
James Holmes. Thank you. You're requesting an adjournment?
Yes, Your Honor. It's a last-minute appointment. I don't.
Hearing no objection, January 15, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case, People versus Othman. Is it Imhoma?
And then on behalf of people.
Your Honor. Austin Obese on behalf of Ahmed Muhammad. Can you state your full name for the record, please?
Ahmed Muhammad. Thank you.
What at this time, we're requesting to set this for preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Preliminary examination in person will be set January 6, 2026, 9 a.m. That is before Judge R. Bond will continue.
Thank you, Your Honor.
Thank you.
What was that date again? No.
Merry Christmas. I'm off this bench. Guess I shouldn't say it out loud. Court calls the case, People versus Jose Shea Danon.
And then on behalf of people.
Aganon, if that's, yeah, I think that's good. Everyone's down?
They were.
They were?
Oh, they are. They're orange chicken.
Oh.
Kermit Adish on behalf of Mr. Jay Ganan, I'm stepping in for APD Pate.
Jay Ganon, you need to turn on your camera. Figures this will happen on your case.
Exactly. No stepping in. To
Who are you stepping in for?
APD Pate.
Hello there. I'm sorry. I just couldn't.
Okay. It's okay. State your name.
Jose Shaigonon.
All right.
Your Honor, I believe APD Pate submitted a green sheet. We are adjourning. I don't believe we have discovery on this case yet.
Don't have discovery yet?
No.
I will adjourn probable cause in this matter to January 15th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right. Thank you. Thank you, sir. Court does call the case of the People versus Dallas Williams.
Good morning, Your Honor. Craig Pappen appearing on behalf of the people for the Attorney General.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Williams.
Your name?
Dallas Williams.
Thank you.
Your Honor, I've had the opportunity to speak with Mr. Williams this morning. I understand this is an unpaid child support. He's currently being garnished the maximum amount allowable by law for 6 separate support orders. He's only getting garnished 6 separate support orders.
Okay.
He's getting about $200 for this particular one, which is ordered to pay $400, but only $200 from his monthly check are going to this order.
Every other week.
Every other week. It's putting him in arrears with many of the orders, but quite frankly, Your Honor, I would like to address bond because I think he just needs to get back to work.
Well, I don't know anything about that, but this is from a period alleged from November of 2020 to July of 2023.
And that is currently being deducted from his paycheck over at Trinity Health. But that portion.
But is that current support being deducted?
With the
It's
6
current, it's current and arrears added to it. Like they added my arrears and my current on that.
But what period?
So the period July to 2023, with the period you talking about, I wasn't working. I wasn't working at all, and like it was hard for me at that time. I was homeless. I wasn't.
Okay, I get all that, but what I'm saying is, I don't think that would be a reduction in bond. I mean,
well,
I think he owed like $20,000.
Yes, Your Honor.
A little over.
And with the 6 support orders garnishing the maximum allowable under the law from his check every week.
I don't know, where is that like an exception? Because the garnishment, the maximum amount of his garnishment.
So I pay $900 a month.
Okay,
Oh, I'm sorry, sir. I'm sorry.
Where is that exception?
Your Honor.
Why would that be an exception?
It is not an exception to his arrearage. However, the court rules only allow a certain amount of an individual's wages to be garnished.
It's a statute that does that.
Statute. I apologize. However, with multiple children with support orders and arrearages, they will take the maximum that they possibly
Which
can.
I think is 25%. So there's another 75%.
Actually, Your Honor, under the friend of the court, they actually take more than 25%.
Okay, but there's still more left.
With 6 support orders, I believe they can take up to 60% of his pay, Your Honor.
Okay, that's fine.
Yes.
The problem is that he didn't pay for almost a 3-year period.
Yes, Your Honor.
So what is the bond argument?
Well, we don't have debtor's prison, and he's getting more and more in arrearage as he sits in jail, not paying the $900 a month.
It isn't anything about debtor's prison. It's about taking care of your children.
Yes, Your
You
Honor.
got anything else in terms of a bond argument on this?
No, Your Honor.
All right, what do you want to do on this case?
Your Honor, we'd like to have a hearing.
You want a preliminary examination?
Yes. The state can bring in their accounting to see how they can take more money from the man.
It isn't the taking of the money, counsel, if that's what you're going for an exam for. It's his obligation that he hasn't paid.
Yes, sir.
This is the raw frustration at the heart of child support cases. The defense argues, we don't have debtor's prison. And Simpson fires back that this is about taking care of your children. Two realities collide in real time. Is this punishment or a system that traps people in poverty and makes compliance even harder? There's no clean answer. Just a brutal problem unfolding in the courtroom.
He hasn't paid.
Yes, sir.
That's the criminal offense.
Yes, Your Honor.
Well, all right. You want an exam? We'll give you an exam. Would the people be able to have their witnesses available the 22nd? Or
Yes,
not
Your
the
Honor.
22nd. When's Landing's Day? The 13th? January 13th?
We can do our best, Your Honor. Thank you.
Right. Preliminary examination in person, January 13th, 2026, 9 a.m. That's before me. Bond will continue.
Thank you.
So that the record is clear. Motion to modify his bond, which is already set at 25%, is denied.
Thank you, Your Honor.
Court knows call the case of the people versus Marcus Jones.
Ashley Phelps for the people.
Kermit Hadush on behalf of Mr. Jones stepping in for APD Pate on this matter.
Fine.
Your Honor, Ms. Pate did not have contact with our client. I'd ask for an adjournment of the PCC. We have not had contact with him just yet.
Defendant. Having failed to appear, a bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court calls the case of the people versus Johnny Payne.
Assistant prosecuting attorney.
Assistant Public Defender Sandra White on behalf of Johnny Payne.
Your name, sir?
Johnny Charles Payne. Your Honor, we're asking for an adjournment. I do think this is something that can, well, you could get waived or worked out, but we're asking for an adjournment.
Not objection. Probable cause conference, January 8th. Yes, January 8th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case people versus Mohammed Kamisoko.
Kind of Overwater assistant prosecuting attorney for the people.
Morning, in Your Honor, Qasim Bobates on behalf of Mohammed Kamisoko, who's present to my right. Can you state your full name for the record, sir? Mohammed Kamisoko.
Okay.
Yes, Your Honor. At this time, we're going to be requesting for an adjournment. We did not have discovery as of yesterday afternoon.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continued.
Your Honor, very briefly, I would just note, discovery packet was created yesterday, so they should have that soon. Additionally, I am informed that the victim in this case is present here, at least in the building, if not in the courtroom, and the victim intended to ask the court for contact with the defendant. People do not agree with that request, but I wanted to make the court aware of that.
And you have no way of responding because you don't have the report. So I'm not going to hear that today, any requests. So bond will continue with the conditions. Thank you. Court calls case people versus Tyree Bibbins.
And Overwater assistant prosecuting attorney.
Judge Christopher Quinn, appearing on behalf of Mr. Bibbins.
Your name, sir?
Tyree Bibbins. Thank you. We would just like to set this matter for exam.
You have all of the discovery?
Yes, I believe so, Judge. Yes. We have a date of January 6th already for another one.
You have what?
Another preliminary exam date for Mr. Bibbins already set for January 6th.
So, I don't. Is this case connected to that case?
It is not, Your Honor.
Is all the discovery on this case complete?
Yes, Judge.
Would people have their witnesses available?
On the 6th?
Yes.
I see no reason why we wouldn't.
Preliminary examination in person, January 6, 2026, 9 a.m. That's before Judge Perry. And we'll continue. Thank you.
Thank you, Judge.
Case people versus Derek McGuire.
And Overwater assistant prosecuting attorney for the people.
Assistant Public Defender Sandra White on behalf of Derek McGuire.
Okay, so they can hear us.
All right, Mr. McGuire, can you state your name, sir?
You tell them your name.
Yeah. You can state my name. What's going on?
You state your name.
I'm stating my name.
Yeah. So tell them your name.
What have I done?
So tell them what your name is.
I'm Derek McGuire.
Yes.
Thank you. All right, I have before me an order regarding I think we already signed one.
That is correct, Your Honor. It's my understanding that the order the court initially signed had the box check directing people to file a petition. We are not electing to do that, so I believe the subsequent order was submitted without that box check. With that order signed, people will prepare an order to nolly cross.
All right, very good. I've signed that new order. Okay. And you're gonna nolly cross
Yes, Your
this
Honor.
case. Any objection?
No, Your Honor.
At this time, I'll just await the order. I'll dismiss the case at this time.
Thank you, Your Honor.
All right. Thank you, Ms. McGuire. Take care of yourself, please, sir.
Thank you very much.
Thank you. Court calls the case, People versus Adam Perala.
And Overwater, Assistant Prosecuting Attorney for the People.
I'm on behalf of Mr. Ferrello. Can you please say your name for the record?
Adam David Perella.
Also, I forgot to, I think, include the case number on the green sheet. I apologize for that in advance.
That's true. You did.
Sorry about that, Your Honor.
How many of those forms has she filled out in the past? Huh?
Can't count.
And she just...
It's when you do one thing wrong, everything else becomes wrong. I didn't add the case number on my file, and so on my notes, and so I didn't have it handy.
So do we really all have to know that?
All my fault.
Probably not. I know it's your fault. Don't do that. All right.
Your Honor, I think we're close to a resolution. We are just asking for a very short adjournment so that the prosecutors, I believe they need to speak to the officers on this case.
Is it, well, let me just ask this. Is it an issue of just paperwork or is it an issue of details you guys still have to work out?
Details we still have to.
Okay. Then probable cause conference, I'll adjourn it to January 8th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Terrell Rickett.
Ashley Phelps for the People.
How about Defender Sandra White on behalf of Terrell Rickett, who's approaching the podium? Can you state your name, please?
Hi, how you doing? I'm Terrell Rickett.
Thank you.
Your Honor, I did have the opportunity to talk to Mr. Rickett. I need to talk with the prosecutor, so we're asking for an adjournment.
Probable cause conference will be adjourned without objection January 15th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Lucinda Printup.
Overwater, Assistant Prosecuting Attorney for the People.
Bangladesh on behalf of Ms. Printup. Ms. Printup, can you please state your name for the record?
Lucinda Printup.
Thank you.
Your Honor, we had adjourned last time to get Ms. Printup evaluated for mental health treatment court. I have that paperwork ready. I'm going to be sending it to the court today, so we'd ask for an adjournment for that purpose. And
We're probably the mental health court in 15th.
Yes, Your Honor.
That we're doing. All right. Is this the only thing she's held on, or is she held on other cases?
Her 14B case, this is the only thing that's holding her. I believe she was intending to post the bond. I believe it's only $100, if Your Honor.
But she hasn't posted that one.
That one I got her on home confinement for, so that she's PR'd on that case.
Got it.
So this is the only thing that's holding her.
Well, okay.
That is correct. I just reviewed ex-jail. This is the only matter holding her bond, 10,000, 10%.
January 15th, 2026, 9 a.m. I'm going to go a little bit further out because the evaluation process needs to be in place. Bond continue. Thank you.
Thank you.
Calls case People versus Stephen Serda. It's him.
Sorry.
No, you were good.
I'm sorry.
It was him who we were waiting on. I did not know you were waiting on him.
Yes, sir.
Thank goodness.
Councilman Bill based on behalf of Mr. Stephen Serda. Can you state your full name for the record, Mr. Serda?
Stephen Salvador Serda, Your Honor.
Thank you.
Your Honor, at this time, requesting for preliminary exam.
You have all of the discovery?
To my knowledge, yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, January 6, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor.
Court calls case People versus Tim Shelley.
Actually, call for the people.
Your name, sir?
Tim Shelley.
Herman Davish on behalf of Mr. Shelley. Your Honor, I believe Mr. Shelley had been released from custody on the Friday. I tried to reach him, could not reach him. He ended up back in custody. I believe his 14B case had picked him up, or he was picked up on that case. So I'd ask for an adjournment so we can discuss this case with the client, and I'd ask for a moment to address one.
January 8, 2026, 9 a.m. Yes, that's the bond.
Your Honor, there is a note on Extra that says that this case is not holding Mr. Shelley. Yeah, right. He did get a PR bond with a backup.
He has a $100, wow, 1,010% bond in this case.
I'd ask for a personal recognizance bond, Your Honor. I believe he posted a bond on. When did you post a bond on this case?
I had a $100 rolled over to a personal bond.
He posted the bond.
On the violation, on the other one, on this one.
I went to it.
I don't. My understanding is that he was arraigned on this case on the violation of this case, but I don't know what that is.
Yesterday?
Yeah.
To my understanding, or what I was told, is that 14A didn't see him yesterday. He was only arraigned on the 14B violation. That there was no violation on this case.
He was arraigned by. I think he was arraigned by. Let's see. Yeah, I think he was arraigned by 14B magistrate.
Yes, Your Honor.
Right.
And he did get a PR bond on that. But
but no, not on this. This one, what was his bond? Sorry. Okay, he had a tether violation in 14B matter before.
Yes, and they did switch.
So they set his bond in this case because of that at 1,010%.
Okay. Okay, sorry. The note on Extra that says he's not being held on this case. Excuse me. I would ask that this bond be lowered to a personal recognizance bond. He did not have any violations on this case. And
what was the tether violation?
I believe they had put him on home confinement. That was an issue.
And then he left? Oh.
No, they switched him to GPS tether, which was more appropriate for this case, I believe.
I went to the address they had on the paper, and that wasn't the address that I live at. So they told me to come back to jail for the weekend. And then when I got back.
Okay, so believe he was put on home confinement. He went to the address that he thought was his home confinement address, but it was incorrect.
No, it was the same address. I couldn't get in the house, and the tether agent told me to stay there till police things out and come back to you.
Let me get the details on that.
That doesn't make much sense to me. I mean, I understand what you're saying. Right. I'm just trying to figure out the part about you had an address that was your home, right, where you were living, right? That's the address that they put on your home confinement tether, right?
They had an address that when I was growing up as a teenager, they had all the paperwork screwed up with the addresses. So
okay, that's what I'm trying to get at. Then the address that they had was not your current address.
Right.
That's what I was trying to get at. Right. Okay. And so, but they had an address on there, and you were trying to follow the order, so you went there.
Right.
But that's not your address, so you couldn't get in.
Right. And I called.
Is there a reason? Hang on. Is there a reason why the place that is your current address, you can't live there.
I live in a trailer by myself.
Right. No, okay.
Right.
I
couldn't
just
live there.
listen to my question. Okay. In this trailer by yourself, is there a reason why you cannot go to that trailer?
No.
So all that happened here is that the address was wrong. And you called, said, I can't be at this address you gave me. And they told you to come back to jail.
Right. And I seen the.
That's beautiful.
And I seen them yesterday, and they gave me a personal bond again on that.
No, I got it. Okay. I mean, you're probably going to mess things up and keep explaining. Go ahead, Ms. Falcons.
That 14B case is a township case, so I have no access to anything about it. But I will note that when the defendant was arraigned on this felony matter, his bond was set at 1,010%, and that would convert to a PR if he got released on the township matter. So it seems to me that if he's been released on the township matter now again,
Yeah, but I think that release on the township. Okay. This is really crazy. Because I'm just trying to figure out where it seems to me that the overall intent was to release him on a GPS home confinement to his address.
Yes, Your Honor.
Right?
our no-go to order is 170 Kansas.
Is that where you live?
I don't mind if he has a PR judge.
That's fine. Yeah, I'll give him a PR, but he's got to be able to. Do you know the address of your trailer?
It's in the
down.
Oh,
okay.
I don't. They asked me for the one next door. It's in a lot.
To do what?
They asked me for the address next door.
Okay, look, buddy. Here's what I'm gonna do.
And Your Honor, they put him
Are
on.
you on a tether?
Yes.
You will be. You're on one now.
Yes, they're supposed to take.
Okay, so here's what. No, I got you.
Your Honor,
I
he's
got you.
been placed on a
Everybody be
GPS
quiet.
tether.
Everybody be quiet. I'm gonna do what I'm gonna do because I don't need any more of your information because it doesn't make any sense to me.
This is Judge Simpson at his most pragmatic, and honestly his most interesting. With bad addresses, bad paperwork, and confusion everywhere, he doesn't see defiance. He sees a system failure. So he cuts straight through the mess. Personal bond granted, GPS tether issue resolved. It's not mercy for mercy's sake, but mercy through practicality. A rare and revealing moment.
Doesn't make any sense to me as to what he's in. I'm going to grant the motion to modify his bond. I'm going to set his bond in this case at a $1,000 personal recognizance bond with a GPS tether. But at this point, I'm going to have it location tracking. I don't know that I need home confinement. And I'll just do location tracking. We might change that at some point to a home confinement, but I'm going to do that, and then we'll seek him. Since I'm releasing him, his probable cause will be the 50.
Thank you, Your Honor.
We'll clean that up. Okay, you got it?
Thank
you. You're welcome. All right, take care of yourself.
Thank you, Your Honor.
Court calls case People versus Matthew Smith.
Office for the people.
Morning, Your Honor. Assistant Public Defender Alexis Zerps with on behalf of Mrs. Smith, who should be appearing by Zoom.
Mr. Smith, can you state your name, please?
Matthew Smith.
You're seeking an adjournment.
Yes, Your Honor.
Probable cause January 15, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
We'll be in touch, Mr. Smith.
Court calls case People versus LaDonta Skinner.
Assistant Public Defender Ben Dunawith on behalf of Mr. Skinner, who is joining me at the podium now. Mr. Skinner, would you please state your name for the record?
LaDonta Xavier Skinner Jr.
Thank you.
Yes, sir.
And, Your Honor, we would like to set this for exam, and I would like to address bond if the court would allow.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 6. Preliminary examination in this matter will be set January 6, 2026, 9 a.m. That's before Judge Perry. Esteban.
Your Honor, my client is currently on a tether from Wayne County, so he'd indicate to the court that he's not a flight risk. He would like to go live with his mother in Inkster, and his community ties through his parents make him not a flight risk. I'd indicate to the court he has a job as a forklift operator at Ford, and he has a bit of a side hustle doing lighting projects for Smart Lighting Solutions. And I'd also like the court to know the police report indicates the phone in question was his property. So at least on the felonies, we don't think there's much of a likelihood of conviction. So Mr. Skinner would ask the court to tether him to his mother's house in Inkster.
What are the numbers on that address? I don't need the street, but on mother's address.
I'm gonna give it to you.
Go ahead.
27036.
It's not on Oakwood.
No.
Because I have a no-go to an Inkster, but I don't. All right.
No.
Anything else?
No, that's it.
Mr. Skinner failed to appear back. And at the time he failed to appear, there was a bond violation for him cutting off his tether. The tether was not recovered, and I believe Community Corrections stated they thought it was possibly thrown in the Huron River. So I do think.
Yes, I do see.
He also has a holdout of Wayne with bond denied for an assault. He has a holdout of Garden City for $500 for an RNO. He has a holdout of Lapeer with bond denied for fraud, and he has a holdout of Oakland for stolen property with bond denied. So at this.
Where's our tether?
Your Honor, I honestly think there may.
You know? Where's our tether?
Oh.
No, that's Wayne County's.
I think you should answer that. That could implicate you in something. Why don't you not answer
He
that?
was out with a tether. It was on his leg, and now there isn't a tether. And I'm just asking where the tether is. You want me to let him out? He doesn't have to answer it. Motion for bond reduction denied. Bond will continue. Thank you.
I want to answer that.
I just want the tether. It's a simple question. Just trying to just impart information. Nobody wants to answer my question. I was curious. I mean, the Huron River is a big place, right? I mean, is it an Ypsi Huron River? Ann Arbor? Might be. I think Denowith knows, but he's not telling. Court calls the case. People versus Laura Waldron.
Sandra White on behalf of Laura Walden. Lorenzo, that's my dad's name.
What'd you say?
I said Lorenzo.
There's your client.
I spoke with Ms. Walden last night. I do expect her here. Can you pass it?
You do?
Yes.
Can we pass it?
Yes, I can give her
Have
a call.
you seen my docket? No.
Well,
where is she?
I don't know, Your Honor. This is something that's close to a resolution, so I would like to call her.
Everything's close to a resolution. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you. Case People versus Kirby Snyder. Two cases. Where's Anna? What? Why is she? Why? Who's recording?
No one.
Oh.
Your Honor, Assistant Public Defender Ben Denowith on behalf of Ms. Kirby Snyder, who stands to my right. Ms. Snyder, would you please state your name for the record?
Kirby Snyder.
Yes.
And Your Honor, we're asking to adjourn for 2 weeks of negotiations. My colleague Stephanie Cannon has secured a release to treatment. For Ms. Snyder from this court, we just need to update our mitigation and negotiate with.
Have they secured a bed for her already? Or probably not, because
No.
they signed the order.
No, Your Honor.
Any objection to the order for release to treatment? All right, court will sign that, as well as it's on a GPS tether, so that will. And you need how much of an adjournment?
I think we're looking for the 8th, January 8th.
Probable cause conference, January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Yeah.
I wonder, does Miss Kirby know where the tether is? I'm gonna find it. Somebody's gonna give me an answer. Court calls the case, People versus Jason Perkins.
Ashley Phelps for the people. Your Honor, Mr. Bridell is in one side, so I understand.
He's in one of the what?
With the side. Okay.
Take your hands out your pocket.
Your last few pockets.
Should I be happy about that? Nothing. What'd you say? What's your name? Huh?
Good morning, Judge. It's Count Rowan. The court should be in receipt of a green sheet. We are asking for a brief adjournment to continue plea negotiation in this matter.
Your name, sir?
Jason Perkins.
Thank you. Probable cause conference, January 15th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. You take your hat off in the courtroom, sir. Thank you. Court calls the case of the People versus Bunny St. John. And keep it off until you get out of my building.
Ashley Phelps for the people.
Assistant Public Defender, defense Edelman on behalf of St. John, who is standing to my right.
Your name, ma'am?
I do believe, well, Ms. St. John, would you state your name for the record? Your attorney's just next door.
Bonnie St. John.
I
have a plea for her. Is that what we're doing?
Yes. This was worked out by my colleague Q. He's next door, but I believe I can hit St. John. If you want to go ahead with the plea, you can just sign your name on the advice of rights form.
While she does that, the plea indicates that she's going to be pleading to a use of cocaine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. The prosecutor and defense agreed to a sentence of 7411 if she's eligible. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that your understanding, Ms. St. John?
Who, what now?
That you're going to be pleading to use of cocaine, the 1-year offense.
Do I have to stay in jail for a year?
No, that's the maximum penalty.
Okay.
Okay, I don't know what your sentence would be, but that you'd be pleading to that. That's an added count 2. Then count 1 would be dismissed, which is the felony charge. Okay, and then the form indicates that the prosecutor and defendant have agreed to a deferred sentence status under section 7411.
What's that?
Okay, was that explained to you by your attorney and what that means?
Mm-hmm.
Okay, then I'm not taking it.
Could we just pass the matter and call it back later today?
Can I get out of jail today?
Okay, listen, I can't do anything, and they're going to have to get her back down. So if that hasn't been explained, I don't know. What I will do, counsel, is I'll do this. I won't put her over into the new year. I'll put her to next week.
I want out today.
Well, our assigned PD is right next door, Your Honor, with the court.
I know, but how many more do you guys have back there? Couple? 4? Okay, somebody better explain everything. I'll have her taken back, but if you guys aren't ready when it comes back, I'm going to be very angry because all of this should have been.
And here's where it all falls apart. A plea deal collapses because the defendant doesn't understand what she's agreeing to, and Simpson is visibly, rightfully angry. This isn't about emotion. It's a basic failure of preparation. His warning is structural, not theatrical. Defendants must understand the rights they're giving up. Now the clock is ticking, and the responsibility squarely falls on the lawyers.
This should have been explained to her.
I will personally
All
do it,
right,
Your
go
Honor.
ahead. Take her back. Bring me the next one. Because she's got 2 cases.
We will send the management, Your Honor.
Court calls case. What? No. What are we doing this one? I have Kirby Snyder. Is that?
I did Kirby's case.
She had 2 cases. What I thought. Court calls the case. People versus Joel. Is it Serbinoff?
Water Assistant Prosecuting Attorney for the People.
Who's that? Is that Burdell? Seriously? Are you ready with your next person? You got somebody there? But
Nope. Joel Serbinoff, Your Honor.
Good. Court calls the case. People versus Vitale. Procopio Vitale.
People?
Assistant Public Defender Ben Denowith, on behalf of Vitaly Procopio, who is standing to my right, I'm standing for our attorney of record, Mr. Besby. Sir, if you would like to waive your exam, you can state your name for the record and sign right here.
Both of these a waiver?
I'm sorry, Your Honor?
Is he waiving on both cases?
Yes. Sign the form, sir. Would you just state your name for the record?
Procopio Vitale.
I know. All right. So you're waiving your right to a preliminary examination in these matters?
Yeah. Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yeah.
You understand you will not have that hearing and that you proceed to circuit court for further resolution?
Yeah, I do.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the case ending in 1429. Bound over to circuit court on the 4 counts with count 5 following. And on the other case, he's bound over on both counts. Your turn.
Your Honor, we will stand mute and waive the formal reading on both cases.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts, all 7. Pretrial in these matters will be set for
January 8th at 1:30 before Judge Slay.
January 8th, 2026, 1:30 before Judge Slay. Bond will continue.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Calls case People versus Joel Serbinoff.
Water Assistant Prosecuting Attorney for the People.
Kyle on behalf of Mr. Serbinoff.
Your name, sir?
Joel Serbinoff, Your Honor.
Thank you, Judge. Today is the date and time set for pretrial. The court should be in receipt of a plea form. I'm not sure if it made its way into the paper file.
I do have it.
Okay, thank you, Judge. Mr. Serbinoff is ready to plead guilty to a reduced count of...
the form indicates that he's pleading guilty to 2 misdemeanor charges, count 3 of use of methamphetamine, the 1-year offense, and a count 4 larceny 200 to 1,000, also a 1-year offense. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Judge.
Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record.
Joel Serbinoff.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. First of all, the added count 3 of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that, sir?
Yes, Your Honor.
And also an added count 4 of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of use of methamphetamine, how do you plead?
I plead guilty.
To the charge of larceny, 200 to 1,000, how do you plead?
I plead guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form or had caused one to be signed on your behalf?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, I do not, Your Honor.
You understand that you're waiving or giving up all the rights that are contained on that form, particularly your trial rights under paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal UBRA.
Yes, Your Honor.
Are you on probation or parole?
No, I am not, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
October 2nd, 2025, at the location of 3500 South State Street, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
Yes.
And did you know what you were using was methamphetamine?
Yes, Your Honor.
All right. And what'd you do involving an iPad that makes you think you're guilty of the larceny?
I had taken an iPad.
All right. The 3500, the address I gave was it's a hotel?
Yes, Your Honor.
And you went into another room and took the iPad, or what happened, buddy?
Yes, Your Honor.
You went into another room, took an iPad with the intent of keeping it for yourself?
Yes, Your Honor.
All right. And you would agree that the value of that iPad is in excess of $200?
Yes, Your Honor.
All right. Sir, if I do accept your plea, I would have to advise you that between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
People are not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
You have, and it would.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be January 30th, 2026, 8:30 before Judge Perry.
Thanks, Judge.
Bond will continue. Thank you.
All right, we'll be in touch, Joe.
Sounds good.
Court calls case People versus Matthew Wallace.
Counsel, what is the prosecuting attorney of the people?
Public Defender Sandra White on behalf of Matthew Wallace. Can you state your name for the record?
Matthew Wallace.
Yes.
Go ahead.
Your Honor, I'm asking for an adjournment in this matter. Mr. Wallace does tell me that he has released the treatment in the circuit court matters. I haven't had the chance to talk to the prosecutor about that, so
he's got a circuit court matter that's pending?
Yes.
Okay. Do you know when your next date on that is, sir? No? It's okay if you don't. That's all right.
I don't.
Don't know? Okay. Let's,
I think he adjourned it out to February because I was supposed to go to treatment, I guess.
I see. All right, so here's what I'll do on this one. I'll adjourn this one to January 15th. Let them try to figure out what's going on and see if we can get this one resolved or how we're going to do it. Okay? January 15th, 2026, 9 a.m. Bond will continue. Okay? Thank you, sir.
Thank you.
Everything else is in custody.
Yeah, minus the,
Court calls case People versus Canaris Williams.
and then on behalf of people,
Assistant Public Defender Ben Denhoff on behalf of Mr. Williams, who is joining me at the podium now. Mr. Williams, would you please state your name for the record?
Denard Williams.
Your Honor, this is the date and time for PCC. The defense is asking to adjourn. We're missing one piece of discovery, and I'm told the link for us to download that was sent, I guess, yesterday. So we need to do that, review that with the client. We're asking for the date of January 8th.
Matter will be adjourned to, are you going to be, you got to get to him with that discovery. What is it that was downloaded?
It's a phone dump report. So like
January 15th, 2026.
Thank you, Your Honor.
9 a.m. Bond continue. Court does call the case People of the State of Michigan versus Bonnie Sue St. John.
Austin Bill Bates on behalf of Ms. St. John. Can you say your full name for the record, Bonnie?
Bonnie Sue St. John.
I have before me a plea form that indicates that the defendant is going to plead guilty to, well, I don't know how she's going to plead. I'm presuming it's guilty.
Correct, Your Honor.
Form wasn't checked. He's going to plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration. Upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement that the defendant would get 7411 if otherwise eligible. As I'd indicated before, that's the full extent of the agreement as the court understands.
That's correct, Your Honor. That's correct. Reflection of the agreement.
Did we get her sworn? Or no? We never even got that far. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Bonnie Sue St. John.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes.
Yes, sir.
Still wish to plead guilty?
Yes.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? No?
No.
Look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of April 21st, 2025, at Montneer Ridge Road in Superior Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
No.
Okay. Did you use cocaine?
The day before.
Okay, let's do it this way. On or about, which may be the day before, maybe the day after, April 21st, 2025, did you have cocaine in your possession?
Yes.
Had you used it?
The day before.
Yes.
Yes.
So on or about that date, you had used cocaine?
Yes.
And you knew what you were using was cocaine?
Yes.
All right. Ma'am, I do have to advise you that if between the time I accept your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be January 20th, 2026. Really? Really? You know, you can't get back. 2026. What time? 10 a.m. before Judge Barr.
Your Honor, I'll note one thing. There seems to be an extra 4 on the statute number for use of controlled substance. I apologize for the typo. 74042B. Just an extra one protected there.
Oh, it should not be 4-4.
It should not be 4, just 1-4. If there's no objection from defense counsel, you may want to change that.
No, I did change. Okay. All right. Good enough. All right.
Your Honor, may I address bond?
You may.
Your Honor, my client is asking for a PR bond at this time while she awaits her sentencing. Due to this charge being a misdemeanor, I don't believe that she's a further to the community nor a flight risk. She just wants to be with her family for Christmas, Your Honor.
Any response from the people?
Leave an expression for.
36 days.
Well, part of the reason she's in is she was using cocaine.
Clean now.
Well, yeah, because you've been in jail, and we don't let you do that there.
But I'm gonna be taking methadone.
So, what do you mean you're going to be taking methadone?
For my doctor.
Did you have another type of substance abuse problem?
Just cocaine. At home.
So were you in treatment before?
Going through my doctor.
Okay, but when's the last time you saw your doctor?
I do it through the phone.
Okay, if you do it through the phone, let's just go with that. When's the last time you did that?
I talk to her all the time.
Remember the last time that you spoke to her?
All right, here's what I'm going to do. Real easy. I'm not entirely saying no, but I'm going to leave it up to. I have no objection if after she speaks with.
I'm supposed to go see her when I get out of here. Go to her office at 8 Mile in Farmington.
But listen real close. I'm not necessarily saying
She also previously had treatment set up at Gretchen's place in Belleville, and she was going to be due to enter there before she got picked up. In late November. Before she got picked up.
In late November?
Yeah.
Day before I got picked up.
That's right, because she basically was warranted because of her use. I'm gonna have Judge Barr's probation department take a look at it before I do anything in terms of her release. So at this time, I'm gonna deny the defendant's request for a bond reduction and then let probation look at it, present it to Judge Barr regarding her release. Thank you. Bond. I'm not, why? Where was she? Who said that? She can't believe anything she said.
She wants training on use no claims.
Who? Are you, that was messed up. You ought to do now. I'm not calling any others back. They're not ready, that's it. It's over. Is that everything for those guys? Until the 12 o'clock? Thank you, sir. Court calls the case People versus Laura Waldron.
People.
This is a recall. This is the recall. We were already done with this. We're recalling the case at the request of Miss White. I would be done off the bench going to lunch, maybe. But no, go ahead, Miss White.
I appreciate it.
No,
Assistant Public Defender,
well,
Dr. White, on behalf of Laura Waldron.
You're good. Sir.
We ask that the warrant be recalled, Your Honor. Ms. Waldron has been going through a domestic violence situation and had to flee last night, so she got here a little late today.
All right. It's okay. As long as you're good.
Yeah.
Okay. Then we're okay.
I hope so.
I'll recall it as long as you're safe.
Okay. Yeah, I'm gonna get a PTO.
I still don't like you. Wait, that's okay.
I believe there's been some talk in this matter, and there may be I'm sorry, I'm just not.
No, it's okay. Go ahead.
There may be a
I waited this long. No.
There may be a resolution in this matter soon, so we're asking for an adjournment.
Any objection from the people?
No, Your Honor.
Probable cause conference.